So what is a UK rep? Well look, it's effectively a redundant term now, because since Brexit the law has completely changed and people really don't understand it. We used to see a lot of EU reps, some UK reps, but it's just not relevant anymore. Here's the reality. If you're going to import a toy or an electrical product into the UK for sale on Amazon or eBay or any other platform, then you absolutely must have a legal entity, a company or a person in the UK based here who can take full responsibility of your goods. So, what does this really mean? It means that you're going to have a contract between you and them which states that they take all of this safety responsibility. It means that you're going to have this company's name and address on your item and on the packaging for that item as well. So what's the result of not having this? If you don't have this and your goods are inspected at the border, they can be seized and destroyed. It might seem like a simple thing. However, it's something that you need to get organised in order to get past the border. Likewise, with Amazon, they check. If you don't have the required markings on your products, your shopfront can be affected, your product can be delisted. So you've got to get this organised. Having this UK company named on your products, they have to be a registered UK company on Companies House. That is not the same as being a VAT registered entity. It's not the same thing. You need to be able to show the contract between you and them. The border authorities will check this contract and they'll also try and contact whoever this named person or named company is, and they will try and find out if they're doing the job properly. If nobody answers the phone, then your goods will be seized and destroyed. So what can we do to help? Look, if you get your goods to the border and you haven't done this properly, we can find you someone who can act on your behalf and take responsibility for the goods, and we can get the goods relabeled for you. But this is all dependent on having the things right. You've got to have the right paperwork, the things have to be safe, you've got to have test reports. You need to get everything right to get it across the border. The same with Amazon. If you're missing anything, this could really affect your sales. So what's the difference between a UKCA mark and a CE mark? Well, the great news is very little. However, it's overcomplicated by people and there's no need. The CE mark is for Europe. The new UKCA mark is specifically for the UK. Now here are the important points. The test reports that you need at the moment for your product, if they're good enough for a CE mark, you can just add a UKCA. Nothing changes in that regard. So what's different about it? Well, if you're going to sell your products in Europe, the UKCA mark means nothing. If you're going to bring them into the UK and sell them here, you're going to have to go with a UKCA mark as of next year. So 2023, everything that used to have a CE mark now also needs a UKCA. You can use a UKCA and a CE mark together in the UK, but if you try and sell it in Europe, the UKCA mark will be meaningless for them. It only gets complicated if you want to bring in medical devices or pieces of machinery. In those instances, you may want to seek further advice before you choose how to mark your product. So what can we do to help? Show us your product. We'll identify what it needs, whether it needs a UKCA mark at all, and then how to get it. We'll point you in the right direction to the right test houses and make sure you get the right paperwork. So, what is a declaration of conformity? Well, I can tell you what it isn't. It isn't a certificate of compliance. It isn't a certificate of conformity or any other set of words put together like that. It is a declaration of conformity. If it doesn't say that at the top of your document, it's not worth anything. If your product comes in and it's covered by the regulations, which mean that you have to CE mark it or UKCA mark it, it must have a declaration of conformity with it. Depending on the product type, will depend on exactly how that declaration is set out, but they all follow roughly the same route. If you've got a toy, for example, though, you would have to put a colour photo of the toy on your declaration. This is a very, very common mistake. If that declaration of conformity isn't completed correctly at the border, they can refuse, seize, or destroy your goods just on this basis. Likewise with Amazon. If your declaration isn't right, they don't tell you how to get it right, they'll just stop your listing. So how can we help? We'll take a look at your product. We'll find you the right test reports and tell you how to add them to your declaration. We'll tell you how to set your declaration out and how to do it in a way that allows you to A, comply with your legal obligations, and B, satisfy the sales platform like Amazon, you've got everything right and you're allowed to import and sell that product. E-scooters, e-bikes, e-everything. Very popular products at the moment, but very, very difficult to get right. People are having entire containers of these kind of products destroyed on a regular basis at UK border points. So what are you getting wrong? Look, first thing you need to understand is that an e-scooter, for example, is not an electrical product. It uses electricity, but for the purposes of the law and the regulations, it's actually classified as a piece of machinery. This means that the law is much, much more onerous and it's much more difficult to get it right. You'll require an incredibly complex test report in order to be able to get this even close to coming across the border legally. You'll have to get your scooter tested to the standard EN 17128. That is the only standard you can get it tested to that the authorities here are going to accept that shows that your goods are safe. You need to make sure that test report comes from a proper, recognised facility. In Europe or the UK, that would be a UKCA facility. If you're getting it done on mainland China, CNAS facility. These test reports have to be right. You've got to be able to match your test report to your product and then write your declaration of conformity. If you can't do this, it won't be coming in. You'll be delisted. So what can we do to help? Before you take the risk and import, let us look at your product, ask us the questions, show us the paperwork. If it's not right, we can show you where to go and show you how to get it right. We can work together to make your product compliant. So how do you correctly classify your product? This is a complex area. You've got to look at two different ideas here. Firstly, when you're declaring your product as it comes across the border, that doesn't mean it's going to be called the same thing as it is in terms of product safety when you're talking to the authorities. Let me give you an example. Your trampoline, when you bring it across the border, will have a very specific number attached to it for paying the right tax and duties. This is the commodity code. Now, whether that trampoline is a toy or a piece of gymnastic equipment will slightly alter the commodity code. You have to understand what the final use of your product is. And the same thing happens when you start to sell it. If it's a trampoline that's going to be used by children in play and they're under the age of 14, it's going to have to be tested as a toy. It's going to need to be labelled as a toy. You're going to need to CE or UKCA mark it. But if it's a trampoline that you're selling for gymnastic purposes, this isn't the same thing. But getting either of these things wrong at the border, whether it be Border Force and HMRC or trading standards, they can seize and destroy your goods as a result of getting this wrong. So what can we do to help? Let us have a look at your product. We can decide for you how it needs to be classified. This allows us to decide that you're going to declare it in a particular way and pay the correct taxes and duties. It's your responsibility, not the responsibility of your customs clearance agent to get this right. Then when you look at the classification of the product for your online sales, we'll tell you what it needs to say and how it needs to be labelled.
Once your goods have arrived into the UK Border Force and Customs will check the paperwork is all in order and check that everything that is said to be in the containers is correct and also in order. If there are any irregularities or any concerns of criminal activity, then under the Customs Excise Management Act 1979, UK Border Force can detain and seize those goods. Such grounds would include duty not being paid, the wrong amount of duty not being paid on the grounds that the goods have been undervalued, the coding is incorrect, or some other issues such as the quantities contained in the container is different to the quantities on the paperwork, or for example, certain items have not been included within the paperwork. If there is any such irregularity, those goods can be detained and seized. If the goods are detained and seized, we can assist you at short notice in trying to have those goods restored into your business. One of the most common reasons for UK Border Force and Customs detaining goods and potentially seizing the goods is their concern that the value of the imported goods is not correct and has been undervalued. When this happens, they will seek payment of financial security, which, if paid, will result in the goods being released for sale. Where we can help is pressing and securing from HMRC, UK Border Force, Customs, evidence that they rely on in their belief that the goods have been undervalued and therefore insufficient duty having been paid. If the security requested has been paid, we can also seek the return of that in due course through the tax tribunal. Quite often the main goods that are subject to such allegations includes clothes and household items, and there are different method valuations that can be applied in determining the correct value of the goods. On occasions, the goods have been detained unreasonably. If that happens, we can issue High Court proceedings and or a judicial review in which we seek the return of the goods and damages. In doing so, we will collate as much evidence as possible to support your case in securing the release and restoration of those goods and compensation. When a seizure notice is issued by UK Border Force, we have 30 days to challenge that notice. In doing so, we will detail why the seizure is unlawful. Having issued the challenge against the seizure of the goods, UKBF have 6 months to issue what is called condemnation proceedings. There will be 2 hearings, one dealing with the ownership of the goods and the second one is the main trial of the case. We will collate your evidence, your witness statements, and prepare and attend the case for you at trial and do what we can to prove to the court that the goods have been unlawfully seized. If the goods have been unlawfully seized, then we can also seek compensation in the event that the goods are perishable and have been destroyed. After a seizure notice has been issued, in addition to seeking to challenge the lawfulness of the seizure if there are grounds to do so, we will always seek the restoration of the goods as a matter of urgency, because we know that you need your goods to be released for business reasons. In doing so, we will make a detailed submission about the decision to refuse to restore, which will include the financial hardship you might suffer, that the decision is unreasonable, and that it is disproportionate. For example, there may be a minor irregularity which you've relied upon would be disproportionate to the decision to not restore the goods to you. If the request is declined, we will seek a review, adding any new evidence that we can, and ultimately we would proceed with an appeal to the first tier tax tribunal and seek an order for the goods to be restored via the Border Force officer reconsidering his decision, which we will always argue is unreasonable. Ultimately, it is your responsibility to ensure that there are no irregularities with the goods that have been imported. Although it might be a factor you wish to use, it is not easy impossible to blame your customs agent for getting something wrong. It is your responsibility. The main issues that we come across is the wrong classification of code, which affects the payment of duty and whether or not anti-dumping duty is payable. We can help you with this at any time. The earlier you seek our advice in relation to the coding and anything else, the better it is for you for the goods to pass through customs into the open market.